Hello, and welcome to the Domestic Violence section of the ULV Justice Center website. During this uncertain time for you, we would like to provide you some helpful information in hopes that you leave here today with the power of knowledge. In this video, we will be discussing the meaning of domestic violence and abuse, domestic violence restraining orders, burden of proof, the restraining order process, and the different types of orders available. Disclaimer. The information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. What is domestic violence? Domestic violence is abuse or threats of abuse when the person being abused and the abuser are or have been in an intimate relationship. For example, married or domestic partners are dating or used to date, live or lived together, or have a child together. It is also when the abused person and the abusive person are closely related by blood or marriage. For more information on domestic violence, see California Court's website. What is abuse? Abuse means to intentionally or recklessly cause or attempt to cause bodily injury to you, or sexually assault you, or to place you or another person in reasonable fear of imminent serious bodily injury, or to molest, attack, hit, stalk, threaten, batter, harass, telephone or contact you, or to disturb your peace, or destroy your personal property. Abuse can be spoken, written, physical, or financial. For more information on abuse, see Family Code Section 6203 and 6230, or California Court's website. So what is a domestic violence restraining order? A domestic violence restraining order is a court order that helps protect people from abuse or threats of abuse from someone they have a close relationship with. They keep the offending party from doing things or restrain them that are considered abusive and provide domestic violence victims the help and separation they need to leave their situations. For more information on domestic violence restraining orders, see California Court's website. Types of domestic violence restraining orders. Generally, there is 4 types of domestic violence restraining orders. One is called an EPO, Emergency Protective Order. Second is a temporary restraining order, also called a TRO. Third is a permanent restraining order. And fourth is a criminal protective order or stay-away order. Let's talk about emergency protective orders, also known as EPO. An EPO is a type of restraining order that only law enforcement can ask for by calling a judge. Judges are available to issue EPOs 24 hours a day. So, a police officer that answers a domestic violence call can ask a judge for an emergency protective order at any time of the day or night. The emergency protective order starts right away and can last up to 7 days. The judge can order the abusive person to leave the home and to stay away from the victim and any children for up to a week. This gives the victim of the abuse enough time to go to the court to file for a temporary restraining order. To get an order that lasts longer than an EPO, you must ask the court for a temporary restraining order, also called a TRO. Temporary restraining orders, also known as TRO. When you go to the court to ask for a domestic violence restraining order, you will be filling out paperwork where you tell the judge everything that has happened and why you need a restraining order. This is also called an emergency hearing or ex parte. Most counties require an ex parte to be done by 10 a.m. the day before the hearing. You must give the anticipated restrained party notice of the hearing with the date, the time, the courtroom number, the county filed in, and a very brief description of the hearing. Some counties permit this notice to be given electronically. Ensure to review the court rules of the county that you are filing in. If the judge believes you need emergency protection, he or she will make the decision of granting or denying you a temporary restraining order. Some courts may make a decision without this hearing, depending on the severity of the claim, the apparent risk, or some factors. The court would then schedule a second hearing, usually within 20 days, that will allow an opportunity for the responding party to prepare a written response. Temporary restraining orders usually last between 20 to 25 days until the court hearing date. You can also visit 2020 California Rules of Court Rule 5.151 for a detailed breakdown and the procedure for a request for temporary emergency ex parte orders, the application, and the required documents. Permanent restraining order. After the first hearing where the judge decides if emergency protection is necessary, there will be another hearing. Ensure you serve the responding party 5 days prior to the second hearing. Even if the judge did not make all the temporary orders you asked for, you can still go to this hearing and ask for those orders. The judge may grant them at the court hearing, even if he or she did not grant them as temporary orders before. At the second hearing, the judge decides whether to keep the restraining order in place or to take it away. The judge may issue a permanent restraining order. Keep in mind, although it is referenced as a permanent restraining order, they are not really permanent due to the fact that they may only last up to 5 years. At the end of those 5 years, or whenever your order does run out, you can ask for a renewal of the restraining order so you remain protected. Criminal protective order or stay-away order. Sometimes when there is a domestic violence incident or series of incidents, the district attorney will file criminal charges against the abuser. This will start a criminal court case. It is common for the criminal court to issue a criminal protective order against the defendant, who is the person that is committing the violence and abuse, while the criminal case is going on. If the defendant is found guilty or pleads guilty, this is valid for 3 years after the case is over. This is a court order that protects you from the defendant in a criminal case. For more information on types of domestic violence restraining orders, see California Court's website. Burden of proof. If you are seeking a restraining order, you will have to provide sufficient proof to support your request. The burden of proof is by the preponderance of the evidence. So basically, you will need for a judge to believe that it is more likely than not that you are telling the truth. Some examples of proof includes, but not limited to, pictures, text messages, voicemails, emails, letters, witness statements, and police reports or incident reports. Declaration writing. A declaration is essentially the story that the judge is going to read. When completing your declaration, ensure facts and proof are current or fairly recent. Everything should be dated in chronological order, starting with the most recent occurrence. If submitting text messages, they should be time-stamped with the date. We have listed useful verbiage and their definitions on the domestic violence sections of our website. It is important when you're writing your declaration, you stay as factual as possible and avoid emotional statements. For example, when describing an occurrence, some will state, "My kids are scared of him or her." We can rephrase that statement to being less emotional based and say something along the lines of, "I am in fear for the safety of our children because," and describe the situation. The restraining order process. An overview. When someone asks for a domestic violence restraining order in court, they have to fill court forms telling the judge what orders they want and why. What happens after that varies a little from court to court, but the general steps in the court cases are here. Step 1. The person wanting protection files court forms asking for the domestic violence restraining order. There is no fee to file. Step 2. The judge will decide whether or not to make the orders by the next business day. Sometimes the judge decides sooner than this. Step 3. If the judge grants or gives the orders requested, he or she will first make temporary orders that only last until your next court date. They will assign you the next court date and it will be located on your paperwork. These temporary orders can include issues like ordering the restrained person to stay away and have no contact with the protected person and other protected people and family pets, child custody, who can use the family home, or who can use other property like a car. Step 4. The person asking for protection will have to serve the other person with a copy of the restraining order papers before the court date. This means that someone 18 or older, not involved in the case, must hand deliver a copy of all the papers to the restrained person. Step 5. The restrained person has the right to file an answer to the restraining order request, explaining his or her side of the story. Step 6. Both sides will go to the court hearing. If you decide not to go to the court hearing, the temporary restraining order will usually end that day, and there will be no restraining order in place. If the restrained person doesn't go to the hearing, he or she will have no input in the case, and his or her side of the story will not be taken into account. Step 7. At the hearing, the judge will decide to either grant or deny the permanent restraining order and can last up to 5 years. Step 8. If the judge also makes other orders in the restraining order, like child custody or child support orders, these orders will have different end dates and usually will last until the child turns 18 or changes are made to them. Step 9. Ensure to complete the restraining order after hearing order of protection form, which will become your permanent restraining order. Make sure the form says what the judge has ordered. Review it to make sure you understand it. It is important to always keep a copy with you at all times. Step 10. You must serve the other person a copy of this order and file a proof of service. For more information on the restraining order process, see California Court's website. Types of orders available in domestic violence restraining order. Domestic violence is a scary and uncertain time. We understand that every case is different. There might be a situation where the victim relies on the abusers financially and is reluctant to take action with a domestic violence restraining order. But it is important to know that a restraining order can serve many diverse purposes, not solely no contact or stay away orders. For example, you can ask the court to grant orders to restrain the abuser from verbally attacking you. These orders will hold the person accountable and possibly assist you in providing a certain ongoing behavior to the courts. There is many different things you can ask the court or a judge to grant you. A restraining order is a court order. It can order the restrained person to not contact or go near you, your children, other relatives, or other people who live with you, stay away from your home, work, or your children's schools, not contact your employer, be subject to audio and video recording, refrain from disparaging or derogatory remarks, move out of your house even if you live together, not have a gun, follow child custody and visitation orders, pay child support, pay spousal or partner support if you are married or domestic partners, stay away from any of your pets, transfer the rights to a cell phone number and account to the protected person, pay certain bills, not make any changes to insurance policies, not incur large expenses or do anything significant to affect your or the other person's property if you are married or domestic partners, release or return certain property, and or complete a 52-week batterer intervention program. Despite the overwhelming emotions you might be feeling right now, know that you are not alone. The ULV Justice Center is here to help. This concludes the overview of domestic violence and restraining orders.